Members of the court, good morning. I will address you, as I did in the first round, on why Myanmar's intent to destroy the Rohingya group is the only reasonable inference that the evidence permits you to draw from its pattern of conduct. I may refer to some of the points in my first speech, but I will not repeat them. I will focus on responding to Myanmar's arguments about their intent in carrying out the clearance operations in 2016 and 2017, as you heard from them last week. One of the great benefits of oral hearings is that the parties have relatively little time, as compared to the written phase of the pleadings, to present their arguments. With experienced counsel on both sides, this normally results in their concentration on the main issues and brings the principal points of disagreement into sharp focus for the court, especially by the time we get to the second round. And such is the case here, with respect to the disagreement on Myanmar's intent in carrying out the clearance operations in the manner it did. For the Gambia, as you know, the evidence is compelling and fully convincing that Myanmar acted with the intent to destroy the Rohingya population in northern Rakhine State for the reasons Professor Sands and my colleagues who spoke yesterday have explained. For Myanmar, in contrast, as they have said repeatedly, their intent was counterinsurgency, to respond to what they called ARSA's terrorism. They have stuck to this story since the beginning of the case, through the counter-memorial and the rejoinder, and at these oral hearings. Mr. Blom-Cooper told you that the inference you should draw from Myanmar's actions during the clearance operations is that, quote, the intent of Myanmar was to confront terrorism. Professor Talman identified a range of hypothetical intentions, but you will have noted that he avoided attributing any of them to Myanmar, and he cannot do so because Myanmar has never argued for them and there is no evidence to support them. In sum, they have put all their eggs in the counterterrorism basket. So the dispute between the parties could not be clearer, and it is this. By the means and manner in which the clearance operations were actually carried out, that is, when the Tatmadaw and related security forces entered Rohingya villages and began shooting indiscriminately, was Myanmar's intent, as reflected in the acts of its state agents, in this case its military forces, to counter terrorism, as Myanmar told you, or was it to destroy the Rohingya as a group, as concluded by the UN fact-finding mission and all the other UN bodies and independent and reputable NGOs whose reports are in evidence, and is further evidenced by the testimony of all of the Gambia's witnesses, both in person and in written statements, and in the reports and testimony of Professor Newton, the only expert witness to have submitted reports and appeared before you. That is the key question for you to answer. In regard to this key question, I will make several points. First, it is now agreed by the parties that genocide can occur during counterterrorism operations. This is a huge point. As Professor Sands pointed out yesterday, Myanmar's lead counsel, Mr. Staker, expressly conceded this at the hearings. The issue is now beyond dispute. Genocide can accompany counterterrorism operations. The mere existence of counterterrorism or other military operations does not prevent the court from finding that Myanmar carried out these operations with genocidal intent. This is fully consistent with the ICTR's judgment in the Akiyesu case and the German court's ruling in the case concerning the Yazidi genocide in Iraq, both of which we cited in our first round and Professor Sands mentioned today. Accordingly, even if you believe Myanmar's counsel, Ms. Laurie, that, quote, ARSA is the reason Myanmar conducted counterterrorism operations in northern Rakhine State, and as we have made clear for the record, we do not, that still doesn't cut it for Myanmar. Thanks to Mr. Staker's admission, confirming what they said previously and repeatedly in their written pleadings, the fact that there was a counterterrorism operation in progress, if that was indeed the case, is pure context. It is not intent. It is not the intent of the state at the time its authorized agents began firing their weapons deliberately at Rohingya civilians, including women and children, upon entering scores of Rohingya villages and began to slaughter the civilian population. To put the question plainly, at the time and in the places where the actus reus of genocide were committed, what was the intent of the state as reflected in the pattern of conduct by its authorized agents, the Tatmadaw, when they engaged in that horrendous conduct? The court has received voluminous evidence on what those acts were and is certainly well aware of them. They were highlighted by Professor Newton on cross-examination, in which he spelled out the various elements of the genocidal modus operandi employed by the Tatmadaw in at least 54 Rohingya villages, based on the findings and conclusions of the UN fact-finding mission. Citations to his testimony and the specific paragraphs of the FFM report to which he referred will appear in footnote. Yesterday, I enumerated them in my speech, as did Ms. Ho, and Mr. Lowenstein, and Mr. Suleiman. Again, citations will appear in footnote. I will avoid further repetition of them. I am confident you know them well and don't need to hear them again from me now. Mr. President, you have been told by Professor Newton during his cross-examination that this modus operandi violated every core principle of a counterterrorism doctrine that is universally accepted, including by Myanmar. Myanmar's acceptance of the doctrine is reflected in the rules of engagement that Tatmadaw prepared for these operations, which state on their first page that they applied to operations against ARSA. As Professor Newton told you, there was no problem with the content of the rules of engagement. The problem was that they were completely ignored in the orders that were given to the soldiers to act as they did, and in the conduct, the pattern of conduct of the soldiers in carrying out those orders in village after village. Every rule was ignored and violated. The fact that multiple Tatmadaw units deliberately blatantly, flagrantly, egregiously, and consistently violated these rules in scores of Rohingya villages spread all across northern Rakhine State, while under the command of their officers, is compelling and convincing and conclusive evidence that counterterrorism was not and could not have been their intent. We say the means and manner by which the clearance operations were conducted against the Rohingya rule out any possible reasonable inference that the operations were conducted with the intent to combat terrorism. The court must, of course, examine the totality of the evidence and make its own determination of what is reasonable to infer from this pattern of conduct. In doing so, it is, of course, free to consider other possible inferences as to intent beyond the two inferences advocated respectively by the parties. If Myanmar's intent was not counterterrorism, as it stubbornly continues to maintain, what could its intent have been other than to destroy the Rohingya group in whole or in part? For example, given the mass exodus of Rohingyas to Bangladesh, does the evidence convince you that Myanmar's intent was to forcibly displace or to ethnically cleanse the Rohingya group rather than to destroy it? Myanmar has not made that argument, and we say it cannot do so because there is no basis in the evidence from which you could reasonably infer that this was Myanmar's intent. The question was put to Professor Newton last Thursday. He was asked, could this have been ethnic cleansing? This was his response, which I will quote in full to avoid any suggestion that we are using it selectively. Based on the facts, as I saw them in the FFM, in those at least 54 up to 76 incidents, my opinion is that it is not ethnic cleansing based on the pattern of practice, the mass rape, the fact that it is documented in multiple witness statements that while those rapes are occurring, they're racist, there are insults, there are ethnic slurs, that the fact that babies are killed, that babies are thrown into burning houses, others are thrown into wells, others are thrown into the river. Ethnic cleansing does not involve killing the children of a particular group. The fact that men were slaughtered after, and sometimes they were hung. The fact that you're shooting at fleeing refugees, emphasis in original. If ethnic cleansing is your goal, you don't keep shooting. You don't put troops on the river as people are fleeing into Bangladesh and sink boats as they're about to get into Bangladesh. And there are others. But the totality of the pattern, sir, says to me that this is not just ethnic cleansing. Professor Newton's testimony is fully supported by the evidence in the FFM's reports, including the following passages from the 2018 report in regard specifically to the targeting and killing of refugees while they were trying to cross the border into Bangladesh. Quote, soldiers opened fire on groups of Rohingya at or close to the border crossing points, including large numbers gathered at the shores of the Bay of Bengal or Naf River while waiting to cross into Bangladesh. Soldiers also shot at boats carrying Rohingya to Bangladesh, resulting in further casualties. Soldiers also used large knives to kill or attempt to kill Rohingya individuals crossing the border. Landmines were planted by Tatmadaw soldiers along border crossing points in northern Mongdaw Township. Soldiers were seen by witnesses laying mines in border areas after 25 August 2017. This indicates that the use of landmines was intended to target fleeing Rohingya civilians and to prevent those who had already left from returning. Data from Médecins Sans Frontières indicated the scale of violent deaths en route to Bangladesh, noting that 13.4% of violent deaths occurred during the period between displacement from their village and arrival in Bangladesh. These facts and many others set out in the fact-finding mission's report led the FFM to reject forced displacement as a reasonable inference of Myanmar's intent, based on the Tatmadaw's modus operandi and pattern of conduct. This is from the 2018 report. I apologize again for the long quote, but it's important not to quote selectively. Quote, "The suggestion that the authorities may have been legitimately seeking demographic change in Rakhine State, as opposed to the destruction of the Rohingya as a group, cannot be reconciled with the scope of violence and brutality of the military or the serious bodily and mental harm inflicted on the civilian population. It would not have necessitated the killing of more than 10,000 civilians, the systematic and coordinated rape of women, the mass deportation of over 725,000 people, and the destruction of villages. An argument that the intent may have been to displace the Rohingya population, but not to seek its ultimate destruction, falls at the same hurdle. The scale and scope of violence in its varied forms, the intensity and brutality of the attacks, and the physical destruction of Rohingya life as it once was, through the mass demolition of their villages and homes, makes it difficult to consider any such inferences as reasonable. When considered against the patterns of oppression and dehumanization spanning decades, and a coordinated and widely prevalent discriminatory rhetoric on the part of the very authorities entrusted with ensuring the Rohingya safety, livelihood, and protection, the picture becomes even more complete. Mr. President, there are stark and fundamental differences between an operation that is conducted to forcibly displace a particular population and one that is intended to destroy them as a group. Let me give you a concrete example of this difference. It comes from your own jurisprudence, specifically in the case of Georgia v. Russia. I will be very careful to keep my discussion of the case uncontroversial, since I was an advocate in that case. Georgia, as you will recall, accused Russia of forced displacement of ethnic Georgians from what was then the Georgian province of South Ossetia, in violation of the Third Convention. Provisional measures were ordered upon Georgia's request. The evidence on which the court relied to determine that Georgia's claims were plausible was this. In 2008, Russian troops crossed the international border into South Ossetia, the population of which was roughly half ethnic Georgian and half ethnic Ossetian, the latter being the group favored by the Russians. The evidence showed that when the Russians arrived at ethnic Georgian villages, or mixed villages, they ordered the Georgian population to leave South Ossetia and head south across the provincial border into Georgia proper. There was no evidence of targeting or significant physical harm done to those Georgians who complied. Where there was resistance, the evidence shows that the Russians started burning some houses and less frequently killed some residents. But the burning and the killing stopped after the rest of the villagers fled. Fleeing refugees were not shot at by Russian forces. Children and babies were not targeted or torn from their mothers. There was no systematic sexual violence. On those facts, if proven, this was forced displacement or ethnic cleansing. It was not genocide. And these facts stand in sharp contrast with what Myanmar did in northern Rakhine State. The court never reached the merits of that case because it upheld Russia's preliminary objection to its jurisdiction. But the court did find that there was forced displacement or ethnic cleansing in the Bosnia and Croatia cases. The situation in Myanmar is, of course, worlds apart from that of the former Yugoslavia. As the court well knows, when Yugoslavia broke apart, some of its constituent republics immediately began fighting over territory. The historical record shows that there was a mad scramble for territory, especially between Croatia and Serbia and between Bosnia and Serbia. Each of these ethnic-based republics sought to expand its territory by taking over areas where their fellow Croats or Serbs or Bosnians lived, at the expense of the other republics and the unwanted ethnic groups who lived there. There was extensive military conflict on all fronts, and tens of thousands, including civilians, were killed. But both the Bosnia and Croatia cases were essentially about the control of territory and the objective of each of the new states to establish an ethnically homogeneous state, or as close to that as possible, by taking over territory from a rival state where their fellow group members lived and expelling members of other ethnic groups. Thus, the court was on solid ground in determining, in Croatia v. Serbia, that the intentions of both states were not to destroy unwanted ethnic groups, but to forcibly displace or ethnically cleanse them from its territory or from the territory it sought in the fighting. Here again, the facts stand in total contrast with what occurred in Myanmar. The Tatmadaw were not seeking to enlarge Myanmar's territory or to defend it against any other state. They were not seeking to gain someone else's territory to bring ethnic Burmese within an enlarged Myanmar. Nor, as the evidence discussed yesterday and today shows, were they simply seeking to expel the Rohingya from Myanmar. We say this evidence convincingly shows that the means and manner by which the clearance operations were conducted preclude any reasonable inference that these operations by the Tatmadaw were intended as forced displacement or ethnic cleansing, just as they preclude any reasonable inference that they were intended merely to combat ARSA. As you have seen, this is what the UN fact-finding mission concluded. And there is still another very compelling reason why it is not even arguable that Myanmar acted with the intent to forcibly displace the Rohingya group from its territory. Myanmar categorically denies that this was its intent, repeatedly. Last Tuesday, Myanmar told you in no uncertain terms that, in the words of Mr. Blom Cooper, the, quote, large movement of Bengalis from Rakhine State to Bangladesh was not the product of a deliberate policy or intent to systematically displace the population into Bangladesh. In its written pleadings, in at least 5 different places, Myanmar makes the same denial. Here is just one example of their multiple denials that they intended to ethnically cleanse or forcibly displace the Rohingyas. This is from the rejoinder. The fact that Myanmar entered into arrangements for the repatriation of those who went to Bangladesh in 1978 and in 1991-1992, and is willing and prepared to accept repatriation of those currently in Bangladesh, is inconsistent with the alleged intention to remove this population from Myanmar. Mr. President, if there is one thing in respect to mens rea that the parties agree upon, it is that Myanmar did not act with an intent to forcibly displace or ethnically cleanse its Rohingya population. It would be striking in such circumstances, and especially in light of the totality of the evidence, including the express findings of the UN fact-finding mission, for the court to determine, notwithstanding the parties' agreement on this point, that Myanmar's intention was to forcibly displace or ethnically cleanse the Rohingya group from northern Rakhine State. The court would be adopting a position that neither party has argued for, that both parties reject, and which is completely belied by the evidence, including expert testimony. To be sure, hundreds of thousands of Rohingyas fled to Bangladesh. But this was because it was the only place to which they could escape being killed by the Tatmadaw, since it was close by and accessible by land or by river crossing, at least for the majority of Rohingyas from northern Rakhine State, and Bangladesh, to its honor, mercifully kept the border open to these refugees. Yes, there might have been a few Tatmadaw soldiers who did not interfere with these border crossings, but they were the exceptions rather than the rule. The fact that so many Rohingyas made it to Bangladesh was not due to the Tatmadaw's kindness, but to the sheer volume of the refugee flow, which made it impossible to stop. Mr. President, it's now 11:30. If I may, I would like to continue with my speech. If a coffee break is desired before I finish, may I suggest that a convenient place to stop would be after paragraph 29, but I'm in your hands.
I think you should complete your statement.
Thank you, Mr. President. I regret to say that we cannot avoid the suspicion that Myanmar, out of desperation, might change its narrative in the second round after we have finished speaking, and there is no opportunity for us to respond further. Subtly, but not so subtly that we did not notice, Professor Talman recalled at the close of his speech on 16 January that 6 years ago at the hearings on provisional measures in December 2019, Myanmar's former counsel, Mr. Shabas, who resigned after the military coup, suggested that there might be other explanations for Myanmar's conduct, including, quote, ethnic cleansing. Was Professor Talman dropping this breadcrumb so that they could say they mentioned it in the first round, thus making it fair game for their second round? We hope not. It would be quite unseemly for Myanmar to make a 180-degree reversal of its long-held position in the second round. And it would be directly contrary to Mr. Blom Cooper's renewed assurances last week that forced displacement was not Myanmar's intent. But even if they leave Mr. Blom Cooper hanging out to dry in the second round, there are other reasons why a reversal of their position would not preclude you from concluding that the only reasonable inference, the only reasonable conclusion to be drawn from the totality of the evidence is that Myanmar acted with the intent to destroy the Rohingya as a group. As I pointed out in the first round, even in a case which is not this one, where there has been forced displacement or ethnic cleansing, a finding of genocidal intent may still be made if the court finds that the intent of the displacement was to destroy the group. On this point, it is worth recalling the court's language in each of its prior cases under the 1948 Convention. In the Bosnia case, the court said, quote, "This is not to say that acts described as ethnic cleansing may never constitute genocide, if they are such as to be characterized as, for example, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction in whole or in part. That is to say, with a view to the destruction of the group as distinct from its removal from the region." That is this case. To the same effect, in Croatia, the court explained that genocidal intent could have been established. That is, that the intent to destroy the group was the only reasonable inference if the evidence had shown that the, quote, forced displacement was carried out in circumstances calculated to result in the total or partial physical destruction of the group. This case certainly meets that standard. As the court has made clear, depending on the totality of the evidence, even where the court has found ethnic cleansing or forced displacement to have occurred, it can also find genocide if these practices, if these actions reflect the intent of the state acting through its authorized agents to destroy the protected group. It is significant that the joint interveners, Germany, France, the UK, the Netherlands, Denmark, and Canada, agree with this at paragraph 46 of their joint declaration of intervention, to which we refer you. Just as ethnic cleansing and forced displacement can be genocidal if they are carried out with an intent to destroy the group, so can war crimes and crimes against humanity. As Professor Sands explained, there is some overlap among these legal concepts. Of course, not every war crime and not every crime against humanity will be genocide. But the specific acts listed in Article 2A through D of the Convention as the actus reus of genocide may also be war crimes or crimes against humanity, which will constitute genocide if they are committed with genocidal intent. In other words, the mere fact that certain crimes are war crimes or crimes against humanity does not preclude a finding that the same acts constitute genocide if the evidence establishes that they were crimes as defined by Article 2, subparagraphs A through D, and that they were committed with the intent to destroy a protected racial, ethnic, or religious group. Here, as we have shown you, the evidence collected by the UN fact-finding mission and many, many others convincingly establishes that the crimes committed in northern Rakhine State were committed with the intent to destroy the Rohingya as a group, and that they constitute genocide. Mr. President, I will conclude by providing the Gambia's response to the final part of Judge Hammoud's second question, since Professor Sands, after providing our answers to the first question and the first part of the second question, left the rest for me. Specifically, I will respond to this question, quote, if there exist other motives or objectives for a state in addition to genocidal intent that can be established by such evidence, would this negate the possibility of proof of dolus specialis as the only reasonable inference? First, we thank Judge Hammoud for this question. And our concise answer is no. This would not negate dolus specialis as the only reasonable inference. And I will explain why this is so. First, or second, as the court has recognized, drawing from consistent ICTY jurisprudence, there is a clear difference between motive or objective of an act or operation and the intent with which it is carried out by the agents of the state. I addressed this issue in the first round, and rather than repeat myself, which we have been urged not to do, I will refer you to my discussion of this point at pages 37 to 43, paragraphs 16 to 34 of the transcript for Wednesday afternoon, 14 January. To quickly summarize, though, motive is the reason or purpose for the action or operation that is undertaken. Intent is the state of mind of the state acting through its authorized agents while they are committing the acts which constitute the actus reus of the crime. In this case, the crimes listed in Article 2A to D of the 1948 Convention. The court recognized the difference between motive and intent in the Bosnia case, where it stated that the intent to commit genocide is, quote, to be distinguished from other reasons or motives the perpetrator may have. It found in that case that a Serb militia massacred thousands of Bosnian men and boys at Srebrenica with genocidal intent, even after finding that, quote, an essential motive of much of the Bosnian Serb leadership was to create a larger Serb state by war of conquest, if necessary. Judge Bandari's separate opinion in the Croatia case includes a detailed review of the ICTY's well-developed jurisprudence on the difference between motive or objective or purpose on the one hand and intent on the other. Among several cases that underscore this difference is the appeals chamber's decision in Prosecutor versus Blaškić. Quote, mens rea is the mental state or degree of fault which the accused held at the relevant time. That is the time when the acts are being committed. Motive is generally considered as that which causes a person to act. As far as criminal responsibility is concerned, motive is generally irrelevant. in international criminal law. The Gambia agrees with what the ICTY rulings cited by Judge Bandari say, quote, that genocidal intent may exist simultaneously with other ulterior motives. This point is not or should not be contentious. Myanmar agrees with us. They agree with us that there is a difference between motive and intent. Professor Talman acknowledged this on 16 January, and I quote his words, quote, motive and intent are not the same. And as I said previously, Mr. Staker agreed that even if counterterrorism was Myanmar's motive or objective, that would not rule out that the Tatmadaw acted with genocidal intent. As applied in this case, even if you are convinced that Myanmar planned the clearance operations for the purpose or for the reason, to use Myanmar's counsel's words, of combating terrorism, that would only give you the motive for the clearance operations. What matters under the Genocide Convention is the intent of the state at the very time its authorities were carrying out these operations in the Rohingya villages of northern Rakhine State. At the very time they were attacking innocent civilians indiscriminately, segregating and executing men and boys, raping and gang raping women and girls, killing children and infants, tossing them into fires, burning Rohingya homes and entire villages, targeting and killing fleeing refugees before they could escape to safety in Bangladesh. And for many months afterward, extending well into 2018, continuing to destroy more and more Rohingya villages, including over 180, which Myanmar admits, they admit there were no ARSA activities, and then bulldozing over Rohingya structures to erase any presence or memory of them, and promoting resettlement by the ethnic Rakhine, or constructing military bases where the Rohingya lived. It is from this pattern of conduct, conclusively established to the standard of fully convincing by the totality of the evidence, that you must determine whether there is any reasonable inference that you can draw other than that these atrocities were committed with an intent to destroy the Rohingya as a group as such. It is not sufficient for there to be another possible or plausible or potential or hypothetical inference to negate dolus specialis, to use Judge Hamoud's words. There must be a reasonable alternative inference to be drawn from the totality of the evidence, not just any inference. We say emphatically that there is none. The only reasonable inference that can be drawn from Myanmar's pattern of conduct, the only reasonable conclusion that can be drawn is that Myanmar acted with the intent to destroy the Rohingyas as a group. This is the very definition of genocide. It is the court's own definition. I will conclude with the same words with which I concluded my speech on this subject last week, which are the court's words in the Bosnia case. Quote, where these requirements are satisfied, the law must not shy away from referring to the crime committed by its proper name. Mr. President, members of the court, that name is genocide. As always, I want to thank the court for its kind courtesy and patient attention this morning and throughout these proceedings. It has been a true honor for me to appear before you in these proceedings. I ask you now to call my esteemed colleague and longtime friend, Professor Darjan, to the podium.